All right, you're good to go.
All right. So, welcome to StartupSac Office Hours. This is a monthly workshop that we host at StartupSac that has topics that we think are of interest to entrepreneurs. So, Jeff, if you want to go ahead to the next slide. So, StartupSac is a nonprofit that focuses on accelerating Sacramento's startup and innovation ecosystem. If you'd like to learn more about us, you can go to startupsac.com. We have all sorts of information on resources that are available in the greater Sacramento region to help you as entrepreneurs out, as well as blog stories that range from telling you about different organizations to interviews with entrepreneurs to recordings of events like this so you can watch them on demand.
And I'll paste that link in the chat here in a minute.
Okay. So go ahead to the next slide. So we'd like to thank our annual sponsors. We are a nonprofit and we don't sell anything. So this is how we are supported, primarily by businesses in the greater Sacramento region who are interested in supporting entrepreneurship. So I'd like to give a shout out to SMUD, Witten Law, Bender Insurance, Nivagen Pharmaceuticals, Stoel Rives, who Chris Russell is our presenter today, Weintraub Tobin, Holcomb Law Group, Clifton Larson Allen, Moneta Ventures, and Ernst and Young. And we're going to go ahead and
one more thing. Oh,
SMUD with we're just going to play a short video, 30-second video for you on SMUD.
My friends and I think about the future a lot.
And it's looking brighter.
Because SMUD's improving our air,
Helping the planet?
and using technology and new ideas to power healthy communities.
Where we can all live, work, and play.
By 2030, SMUD will be 100% carbon-free, so you can live in a clean power city. Join the charge with SMUD at cleanpowercity.org.
My friends and I.
And now we're going to make you watch it again. just kidding. So we're going to go ahead and get right into the program because that's what you came for. As I mentioned, our presenter today is Chris Russell with Stoel Rives. Chris is a corporate attorney and partner at Stoel Rives. I've known Chris, I think, for 14 years. I used to work for another nonprofit called SARTA that worked with entrepreneurs as well. And Chris was on the board of directors there. So I've worked with Chris a lot. I've seen him teach this workshop and others. So I think you're in for a real treat. So with that, we're going to go ahead and stop sharing our screen and invite Chris to share his and also spotlight Chris. During the presentation, if you have a question, you can go ahead and type it in the chat, and then I will let Chris know if it's a question we want to answer right now or if we want to hold till later. Also, one of the questions you don't need to ask in the chat is whether or not Chris's slides or video will be available later, because we will share that on our blog probably by early next week, and we'll also send everyone who's registered an email with a link to the slides and the video. So without further ado, Chris, you can go ahead and share.
Okay, I don't know what happened here, but let me just skip out of this. Let's see. Here we go. And
we can see them now.
Okay.
But you're not in presenter mode yet.
There you go. Does that work?
Yep. Perfect.
Good. Hi. Just as a brief introduction, thanks for the introduction to Laura and Jeff. I'm Chris Russell. I'm a corporate partner with the law firm of Stoel Rives. I've been working with early stage companies for the last 20 plus years in a variety of different ways. And and this topic comes up a lot when I meet with early stage companies and they're trying to get started and they need to think about what their next steps might be and how they might want to organize their business. So this is just an overview of some of the issues that startups should consider when as part of their startup programs and answer questions. Feel free to raise your hand and ask questions, and Laura will help me identify them because I may not see them. But go ahead and raise your hand, and if during the presentations you have any particular questions, we can try to address them then, or we'll have time at the end of the program for that. So the topic again is common startup mistakes. The first one we're going to talk about is choosing the proper business entity. There's a variety, as many of you know, there are essentially in these areas, there are 3 types of companies that are typically used for startups in doing technology-based companies. They're an S Corp, a C Corp, and an LLC. And how you choose between those particular, I see it, there's a typo there. As you choose between these, these are the types of issues that would come up in determining which one is the most efficient for you. You would be looking at tax issues, ownerships, and to what extent are you going to need to raise additional capital, or are you going to be self-funded, the type of corporate structure that you might have, and as a collateral, any employee compensation issues that might come out could have an effect on determining what's the appropriate entity to choose. So in terms of tax, this is very summary, and I'll just go through it quickly because a lot of people understand this. But with respect, a way these entities are taxed, the corporation is treated as a separate legal entity from its owners, and because of that, it is being taxed. The corporation is taxed on its own operations. And so that's one level of tax that we're talking about. And then if you want to distribute any of the proceeds or anything from your company or up to the members, then that's a distribution or a dividend. And that dividend is not tax deductible at the corporate level, and it's subject to a tax at the shareholder level. So when I refer to 2 layers of tax, it means when you want to pass income either on a sale of the company or revenue that's generated during the business, if money is going to come from the company up to the shareholders in a C corporation, it's going to be taxed at the shareholder level, as well as the profits being taxed at the corporate level. For an LLC, is what we have here is like a flow-through model. So even though the LLC is treated as a separate legal entity from its members, for tax purposes, the operations, the income and profits of the business are determined at the LLC level, and then they provide K1s up to their individual members, and the individual members would then either include the income or loss on their personal income statements. And so because it's being taxed at the individual level, each member is going to be subject to some tax on the operation of the business, or have some tax benefit if there's a loss going forward. There's limitations on the uses of losses to only those people who are actually actively involved in the business. If you are a passive investor, then the use of those losses would only be used against other passive gains that you might have from your other investments. So there's some limitations on the use of losses going forward up to the LLC. But if you are actively involved in the business and you're operating your startup company, and it's generating a lot of expenses but no revenue, in that context, the expenses that you're incurring at the company level is going to be shifted up to the members, and the members would be able to take those losses against other income that they might have against from other sources. So one factor is to look at what your model of business might be. An S corporation is similar to an LLC in the sense that it provides the profits and losses will be allocated up to the members, but there's some more restrictions around what and how you might be able to use an S corporation, which we'll talk about in a few minutes. As between the LLC and the S corp, there are issues that you would be talking about in terms of flexibility in allocating the income and losses. For instance, in a S corporation, allocations of profits and losses can only be allocated on a pro rata basis based upon the membership of the ownership of the company. Versus an LLC, you can allocate your profits and losses where there might be disproportionate losses going to one segment of your members and not others. And this is typically what happens when you have if you have someone who has an investor comes in your LLC and wants a priority return over the other founders in the LLC, then an LLC would permit the allocations of losses to those particular investors in a different way than it would be that you could do it with respect to the founders. As we talked about before, S corporation can only be done based upon pro rata, based upon ownership. So there's a difference between there in terms of how between the LLC and the S corp and how they do it. There are other issues that come in, but this is high level. There in terms of how this might be taxed. There's also a tax at the state and local level. For an LLC, the state, California, imposes a 1.5% tax on net revenue. So if you have net profits, you're going to pay an additional 1.5% on that for tax to California. LLCs, on the other hand, they're taxed on gross receipts. So it doesn't matter if there's losses, it's the amount of money that comes in. It's graduated up to a fixed amount, depending upon your level of revenue. It starts out really low, but once you get to like $5 million in revenue, it's roughly about $12,000 in tax annually on an LLC. So there's some there's some advantages at the state and local tax level there as well. In terms of who can own one of these entities is also important in determining which entity to choose. For a C corporation, which what we talked about at the beginning, which is just a regular corporation that you would file, it's taxed like a corporation. There's no limit on the number of shareholders that you can have, or where the shareholders are from. Are they U.S. citizens or not U.S. citizens? There's no limitations on that. For an LLC, there's an effective limit of 100-member limit to the extent, there are some rules that come into play that says if you're a publicly traded partnership for tax purposes, and LLCs are taxed as partnerships, then it's, and when that trigger is around 100-member limit, depending upon other factors within the company. But if you meet the criteria for a publicly traded partnership, then you're taxed like a corporation. So it takes away the disadvantages of using an LLC in that context. And an S corporation is more limited. It only allows individual people, up to 100 individual shareholders in the company. All the shareholders must be individuals or natural people with limited exceptions, like you can have revocable trust and other things, or there might be certain trusts that qualify for it. But from a perspective, it should be viewed as only as individuals. And then all the shareholders must either be U.S. citizens or U.S. residents. And so that might limit the scope of who might go into your S corporation, and might be a factor why you might choose an LLC over an S corporation in that context. Another thing that you need to take consideration when choosing a business entity is fundraising. And what I mean by that are you going to be funding the operations of your business on your own, self-funding, or through a limited financing abilities, or are you going to be raising institutional money or from other types of people in like VCs or angel groups or other things like that? If you're going to a more traditional investors like VCs and many angel investors, they often prefer to invest in C corporations, and there's several reasons why that is a place. Some of them was that we talked about previously, but just from a very technical standpoint, most of these will want to invest in C corporations, and many VCs can only invest in C corporations. VCs can, since VCs and institutional investors are not individuals, as we talked about, they cannot invest in an S corporation. So if you have a non-natural person like an LLC investor or a limited partner who's coming in, a partnership who's going to be one of your investors, it can only come in as an LLC or a VC. It cannot come in as an S corporation. An LLC also provides some flexibility. What we talked about, you can have some provisions in your agreement which gives some preferences to certain investors over others, but the LLC agreements are somewhat complex. And when trying to raise capital, you want it to be as simple as possible. And that's why, many investors are very familiar with how a corporation would work, who the board, it's very structured on who it's controlling by. And the LLC is much more flexible, as we'll see. And the investors would have to go into more deeper dive into what the LLC agreements say. And in many cases, in a corporate standing format, the formats of what the company looks like, the form documents, all fairly standardized, whereas in LLCs, they are not. So one who is making a choice between investing in a VC and an LLC, it's going to be easier for the investor to invest in a corporation because those particular documents are more standardized and they could quickly review them. With an LLC, you have to hire some lawyers to go through and review it and understand the rights and remedies under those particular provisions. So those are some of the factors in choosing whether or not you would which entity you might choose. Another thing that you need to think about in terms of which entity is the best for you is how it's governed. But corporations, both CNS, I'll just be really clear. From a state law purposes, you form a corporation by filing with the Secretary of State's office, and that is regardless of whether or not it's a C or an S. They're both statutory creatures. How you change between a C and an S is that you file an election form with the IRS that says that you want to be elected to be taxed like an S corporation, but it is a corporate form, and the corporate laws apply to both C and S rules. Corporations have well-defined corporate structures. It's a statutory creature. So in essence, what you have is that you have shareholders in a corporation who elect a board of directors, and the board of directors have the ultimate control over the course and conduct of the company, and it can allocate authority to operate the business on a day-to-day basis to its officers. So you would typically have shareholders elect the board members. The board members would elect officers who would run the day-to-day aspect of it. So it's a very straightforward, defined corporate governance structure, and you really don't have flexibility to move beyond that particular structure if you're using a corporation. An LLC, on the other hand, can mimic almost any type of other type of business entity. It can mimic a corporate form where you have members who elect board of managers, board of directors, and those would also elect officers of the company. So you can have something that looks like a corporation. You could have something that looks like a limited partnership where you have a manager who has complete control over the business, and all the other members are just passive investors in the company, but the manager has complete control over it, similar to like a general partner of a limited partnership where they have complete control of it. Or you could have it structured like a general partnership where all the members have a say in the business of the entity, and all the members would have authority to act on behalf of the LLC. So you have a lot more flexibility on how you might have a corporate governance in an LLC form than you would in a corporate form.
Chris.
Yes.
There was a question relevant to one of your earlier slides. What does it mean to accidentally become a public company?
Okay, so there was one of the slides that talked about if you had too many shareholders in a corporation, you could end up becoming a public company. That there's a rule in the 1934 Act of Securities Act of 1934 that says if you have over 2,000 shareholders, which is a lot now, it used to be the cap at 100, and then it was much more of an issue. But if you had over 2,000 shareholders, exclusive, you don't count anybody that you might have done in crowdfunding. Those are just a different class of people. They're not counted in that particular number. But if you have 2,000, then you still have to start filing reports with the SEC as if you're a publicly traded company without actually raising any capital. Did that answer the question?
Yeah, it sounds like most of our entrepreneurs here probably wouldn't encounter that issue,
Yeah.
at least not at this stage.
Yeah, that's why I didn't discuss it. Okay, so one of the other factors that you would consider in determining which type of business entity that you would look at is if you're trying to compensate your employees or other people or consultants who might be working with you in that context. For a corporate form, it's very structured. You have a stock option plan. Typically, the corporation will compensate employees through options, and I won't go into reason why people use options over other types of things, but I'd be glad to talk about it if there's a question that comes up about that. But most employees and corporations are compensated through stock options. They're fairly straightforward. It's the documents are there and people understand how they work. The same thing would happen in an S corporation, but you also need to be mindful of the limitations on the number of shareholders and who would be able to become a shareholder if you granted someone an option. So, like for instance, if you granted someone an option that was not a U.S. taxpayer, that doesn't get rid of your tax exempt status. But if that person exercises that option to become a shareholder, then you would immediately stop being an S corporation and you'd start being taxed as a C corporation. So you need to plan. If you're using an S corporation, you're trying to compensate with employees, you need to make sure that your plan or agreements contemplate what you might do if someone would cause the company not to be an S corporation. Typically what would happen is that the company would have the right to buy the stock back out at that point in time. And LLCs are treated a little bit differently. I mean, the principal way in which employees are compensated, and what I mean by compensated means that they're not paying capital into the company. They're receiving a profits interest in the company to receive the benefits of the appreciation of the company going forward. That is done through a profits interest in the company, and there are some a little bit complexities in that. The people who receive profits interest are typically members of the LLC, and one of the things that you need to think about in terms of how that would affect the employee is that if they become a member, then they're like a partner in a partnership, and instead of getting W-2s from the company, they would get K-1s, and that could be some problematic for some people because they might be allocated profits and they might not have the income to be able to pay any tax that might become available to it. So it is a little bit more complicated than an option, but there are ways that you can compensate employees through an LLC as well. All right, the next one I wanted to talk about is,
Chris,
yeah.
Are you going to talk about choosing where to incorporate, such as incorporating in Delaware?
I don't have a slide, but I'd be happy to talk about that.
Okay, we have some questions in the chat about that.
Okay, so where you may have choose to form your entity is, I mean, if you're operating in California and your principal business in California, most people will choose between one or two states of incorporation. One would be California, and the other one is Delaware. And why do people, in California want to incorporate in Delaware? Well, the principal reason is that the laws although they're very similar in how they're structured, a Delaware corporation is structured very similarly to a California corporation. A California corporation typically includes more minority rights than a Delaware corporation. So they have rights where a minority owner, if they own a percentage of the stock, may be enough to be able to appoint themselves to the board under a cumulative voting arrangement, which under a Delaware law, only a majority, the directors are appointed by the majority owner. So so there's some flexibility in where minority shareholders might be able to have additional rights than in the corporate form. And if you are looking at trying to go and raise capital through institutional money, the institutional money will typically want you to be incorporated in Delaware, because it basically, in Delaware, it's a contract state. People get to decide what their obligations are to each other, and those will pretty much be enforced in Delaware. Where in California, if you have provisions in your articles of incorporation that are inconsistent with the California statute on minority rights, then it's not valid. So many times investors will prefer to have it really clear on what their obligations and rights are in Delaware. The other factor is that since almost a high majority of all corporations, which are publicly traded companies, are incorporated in Delaware, Delaware has a very, very rich judicious history of what the law means. So there's a lot more certainty on what your fiduciary duties are in a Delaware corporation than there might be in a California corporation. And that becomes really important for investors who are coming in, because they will be typically will want to sit on the board, and they will want to know what the fiduciary obligations are going forward, and it'll be much clearer in a Delaware. So that's another reason why people would prefer a Delaware corporation. So if you're looking at raising capital through institutional investors through a corporate form, Delaware will be the natural selection for you. If you are primarily operating the business, with friends and family, and not really intending to raise a lot of capital from outside investors, then an S corporation, the issues that might arise in the minority rights and other things in the S corporation wouldn't be as problematic, and you could probably reduce costs because you are only qualified to do business in California, and you're not having to pay additional fees in Delaware. So those are some general factors in determining the state of incorporation, but you typically have a choice between California and Delaware.
Chris, if you register your corporation in Delaware, but you're located in California, don't you also have to register something with California as well, or pay California some money?
Yes. In essence, what happens is that if you are qualified to do business, if you are registered in Delaware, and you are doing business in California, you have to qualify as a foreign corporation in California. Foreign just means non-California. And so that could be other states as well. And what that is a relatively straightforward form, but it then puts you in the exact same place where you have to pay $800 per year of the minimum franchise tax, and you have to file tax returns in the US. It really kind of depends on your stage in the operations and whether or not you need to qualify to do business in California and what your activities are. Like, for instance, I've worked with several people at UC Davis, and they are primarily raising, just forming a company in order to qualify to do grants, but they're not otherwise yet in the process of doing anything. And I haven't hired anybody. In many cases, they will defer qualification to do business until they're actually doing something in California. So there are some timing factors of it. But if you're registering in California, I mean in Delaware, and you're immediately doing business, hiring employees, other things, entering into contracts in California, you will have to qualify to do business in California and pay the minimum franchise tax fee like any other California corporation.
There's one more question in the chat. Maybe we could just talk about briefly, and that's B corporations. If you could explain what they are.
Yeah, so I mean, they're the benefit corporations. I mean, they're the in essence what they, you know, various different states have different types of laws related to this, but the principal issue there is that you would have some form, the company is being formed for some social purpose or things along those lines, and they would state that in their articles of incorporation. So, and what is the benefit of that, or what's the downside of that? Well, the principal issue there is that with the corporation, the board of directors have to make all their decisions with the best economic interest of the shareholders. And so if they make decisions that are not in the best interest of the economic interest of the shareholders, then the shareholders could bring in litigation against the director for breach of fiduciary duty. With these benefit corporations, the board of directors can also take in consideration the social purpose and not just the economic interest of the shareholders when making decisions. So it changes the fiduciary duty requirements for the directors to permit them to look at other issues other than just economic issues.
Okay, thank you, Chris. I think we're ready to move forward.
Okay, great. So, you know, whenever you're forming a company or forming an LLC, you're going to be issuing stock to founders and to other employees, and as you raise capital, you'll do it into investors as well. And there's issues that you should be any startup should be aware of when they're issuing stock to founders and to others. And so one of the questions is that, you know, in founder stock, if you just issue stock to some, you know, you have 3 founders and you issue 1/3, 1/3, 1/3 to each of the founders, and you don't subject the founder stock to vesting. So that means that they have to be around for a particular period of time in order to get the benefit of those stock. So if you had 3 founders and you granted each of them 1/3 of the outstanding stock, and that one founder leaves the next day after receiving the stock, then at that point in time, that person owns 1/3 of the company, and you have no way to pull those shares back. And so they will get the benefit of all your work, and you know the other 2 people will go do all the hard work in terms of doing the business, and this other can just receive the benefit from it. So in many cases, co-founders will enter into what we call a restricted stock purchase agreement at the time of receiving their shares. And what that means is that if someone leaves before the vesting occurs, then the company has the right to repurchase those shares that are not vested, typically at the price they paid. So, like for instance, if in early stage companies, the founder's price is really, really low, and if they create some value and it appreciates over a period of time, and a founder leaves before the fully vested, the company would buy it back at the original purchase price, even and not consider the appreciation that might occur. So that's a concept of, on the vesting arrangements, you to the extent once you're vested, you typically be able to own your shares and benefit going forward. But if you leave before the vesting period, the unvested portion is typically subject to repurchase by the company. In the vesting arrangements, there's usually some form of acceleration if the employee is terminated without cause or leaves for good reason after a change in control. So there's there can be some flexibility in terms, like if someone, like if you have a change of control, then you may want to have everybody vested and be able to participate in the change of control at that point in time. The final point on this slide is an important one. I mean, many founders may say, well, I don't want to be subject to vesting. Well, if you go and you try to raise institutional money, a venture capitalist or your investor may very well want to make sure that you stick around in connect to be able to grow the company in connection with their investment. And one way that they might do that is they might require the founders to enter into an agreement where they subject their shares to vesting at that point in time. So and so it may be better to do this up front if you're thinking about having a VC investor come in, because then you have the clock ticking and you could show the investor that you're already subject to vesting and here's what it is. But if a VC comes in, then they may very well negotiate where they would want you to be subject to vesting as you go forward. The other thing that people need to do, especially when you're doing a restricted stock, and this is really somewhat important. Basically, the rule is when you receive stock that's subject to vesting, for tax purposes, for IRS tax purposes, you are not in receipt of the property until it vests. And what does that mean? Well, if you receive property from the company, like cash or salary from the company, it's income to you. And so if you enter into a restricted stock purchase agreement and your shares don't vest for a year, and the company appreciates over that period of time, and then it vests, then on the vesting date, you would have an income event for the portion of the shares, the value of the shares that it had just vested. And one way to deal with this tax issue is that founders or other people who receive a restricted stock purchase agreement will file what we call an 83B election with the IRS. And what that means is that you're telling the IRS that says, notwithstanding that the shares are subject to vesting, I am taking into income today the total value of these shares, and I will pay tax on the total value of these shares in excess of what I paid. So in most cases, in the founder situation, they'll pay a very, very small amount purchase price, but that's also the fair market value of the shares. And so if you take all of the income in, all the shares in the income as of that date, you're not paying any tax because you paid fair market value as of date. The risk comes in is if there's appreciation, and if you don't file the 83B election and the company appreciates over time, on each vesting date, you're going to recognize an income event. And so the 83B election eliminates that particular risk. The one thing that you need to be aware of is that this must be filed within 30 days of receipt of the stock. If you don't receive it, if you don't file the 83B election within 30 days, then the election is not effective. So, and then you're back into the situation where you have you could be subject to vesting, and the company could be subject to, you could have receive an income event, and if you're an employee, the company could have withholding obligations on each vesting event. And so that's not the preferred way to do this, and that's why they're typically tied to restricted stock purchase agreement. The other thing that you should be aware of is that when you enter into an investment arrangement, you're enter a stock purchase agreement or you sell the company, there will be most likely some reps and warranties around this, because they don't want to have their, if you don't properly file the 83B election, then the company could have withholding obligations on vesting events. And that could mean that some of the company's money is then being paid to the investor's money. And so they will check to make sure, many investors will check to make sure that these are done on a proper basis in order to prohibit that particular thing. So that's an important thing to remember. The other thing I found is this has been a common problem that I find a lot that's going on. When I talk to founders, they tend to talk about how they're going to split their interest in percentages. I'm going to own 30%. He's going to own 40%. He's going to own whatever, 40% or whatever the numbers would be. But they don't talk about it in the terms of shares. And so when you're offering shares to, and then when you try to hire a CEO or bring in some other people, they say, I'm going to give you 1% of the company. And they sign something in a document, send out an offer letter, says, I'm going to give you 1% of the company if you join the company. Well, what does that 1% mean? 1% of what and when? So in many cases, I recommend that people put in a fixed number of shares. So I would say 1,000 shares, which as of today represents 1% of the outstanding shares. Because I had a problem once when I had a client who had sent out an offer letter that was signed that says, I'll give you 5% of the stock. They never drafted or even put the stock into place. The company was about to be sold. And this guy came back and says, well, I get 5% of the total purchase price, notwithstanding there's been a lot of issuances from the date that person, which would have diluted their interest if they had been issued up front. So make sure that you, when you talk about it, you put it, you talk about it in terms of number of shares, how it's going to work, and don't put, describe that you're going to give them percentage. It really should be more structured than that, because you could run into risk related to that. The other thing which we were talking about, like companies when they're granting stock options, there's also the issue there. In most cases, we use stock options for a company in order to not have typically the options are not taxable upon grant. So like if you grant someone 5,000 shares at 10 cents per share exercise price, that granting of that option is typically not a tax event for tax purposes. It would be a tax event when someone exercised the option, but not when you grant it. But there is an underlying issue that also comes into play, which is Section 409A of the Internal Revenue Code. What that means is that if you grant an option to an employee at less than fair market value, that differential is deemed to be deferred compensation to that employee. And that differential would be subject to a excise tax on the individual. So that's a 20% excise tax that the individual shareholder would have to pay, employee would have to pay if you don't grant them at fair market value. So that this then becomes a really key issue on why companies grant options at fair market value. There's other reasons why, but this is one of the principal reasons. How do you determine fair market value, and especially for a startup? And those are, the IRS is giving us some safe harbors. If you use a qualified individual who can prepare an evaluation report, you can rely upon that. Outside of, and that's where you get a lot of what we call 409A valuations that you might see going forward, is that on an annual basis, a corporation may bring in someone on an annual basis to understand what the company value would be, and then they would key the exercise prices for options going forward on that particular thing. Early stage companies may not have the funds to be able to bring in an advisor to do this. And so, you're outside of the safe harbor, but then you're just working with what the board would determine to be the fair market value. But they would need to be acting reasonably since it is outside the safe harbor, in the unlikely event that the IRS would look at this, then they may have a different viewpoint of what that valuation would be. But with respect to early stage companies, there's probably not a lot of risk related to a 409A. The IRS is going to come in and appraise this, but it's something that you should be aware of because it could affect your employees going forward. The other thing to be mindful of when you're issuing stock to both founders and to others is that stock is subject to is a security, and you need to be careful that you issue these shares to the appropriate, under the appropriate security law exemptions. And there's two components of this. One is whenever you issue securities and you commit fraud, and I'll talk about that in a minute. Then what that does is it provides a basis by which the shareholder would have a right to come back and rescind the purchase of those, and you would have to pay it back. So it gives them a period of time under which they would be able to look at what the company has done and to see whether or not they want to rescind it or not. What is fraud? Basically what you intentionally make misstatements of fact to make a material fact which would affect an investment decision, or you fail to disclose facts that made your prior statements misleading. So, like for instance, one of the things that I typically look at is like, the company might say, we're gonna make through this process we're going to be $100 million company in 5 years. Well, that's a statement without qualification, and that could raise issues for fraud issues where someone is saying, well, if you don't rate, that's a pie in the sky thing, but if it doesn't happen, then they might have a fraud claim against you under that. So you typically caveat these types of things and you say, parties, the plan typically, contemplates that we would, get this type of revenue over a period of time. And then you would always qualify it with, that these are just forward-looking statements type of thing. So there are some ways in which you can qualify your statements when you're trying to raise capital with people, so that, and you want to use forward-looking statements, you would just make sure that they understand that these are just projections and not something that you're making a decision or a covenant for them about that. So it's a complicated issue, but it's just something that you need to be careful of, and you need to be aware of what you say to people if you're asking them to invest in your company. When you're fundraising, you have to, that's the fraud issue. And then the other flip side is, if you have to, under the securities laws, there's you either register your shares or you be exempt from your shares. When I say register your shares, I'm saying you're registering an IPO, going for the full prospectus, you're registering it with the SEC, and they're going to review your documents and determine whether or not to approve it or not. Most companies don't go that route. Most companies rely upon an exemption from those registration requirements. And in California, there's, the most typical exemptions that we have is what we call a 25102F, which is basically, it says that you can issue shares in a particular offering, and there's a range around that. Up to 35 non-accredited investors, and then an unlimited number of accredited investors. What does that mean? What does an accredited investor means? It's means someone who is has basically $200,000 in income over the last couple of years, or $300,000 with their spouse over the last couple of years, and the expectation of the same type of revenue going in the following year, or they have $1 million worth of assets exclusive of their home. So that's one basis of accredited investors. There are also, the executive officers of your startups would be an with accredited investors. Basically, the idea behind accredited investors, they can take care of themselves. They know enough information, sophistication around the company that they would be able to see that. But there's particular criteria that you would have to meet to be able to do that. So when you're doing it in your early stage, you know, in the founder stage, you're probably not all the founders are probably not accredited investors. And so you could just rely upon the less than 35 non-accredited investors at that point in time. And you would file your exemption both with the state and then with the SEC. There, you file a notice requirement, 25102F notice with the state of California to perfect an exemption in California. And if you're relying upon an exemption under form regulation D of the SEC, I mean, then you file something with the SEC, so form D. So it's a similar type of notice arrangement by that. But it's something that you need to be aware of when you are talking to other people and how you present your company and in slide decks and other things to make sure that you are complying with these issues. The other aspect of it is in most security law exemptions is that you're not using general solicitation. What does that mean? So like you're doing a private placement, a private offering. You're going to talk to people that you know or that are connected to in some way. You're not posting on the internet, like on your webpage here. If you want to invest my company, click here and make it in, and you'll be able to learn about my company to be able to make an investment. That's general solicitation. You know, putting an ad in the newspaper, other types of things are general solicitations. And generally, their general solicitations are not permitted in offering securities under California law unless you're relying upon what the SEC has for in Reg D. They do have one limited type of if you're offering only to accredited investors, then you only selling to accredited investors. You can use a general solicitation, but the downside is if you are not using general solicitation in your offering, you can rely upon statements or representations from the investors as to their accredited investor status. And you don't have to go deeper unless you have a reason to believe that these statements are incorrect. However, if you're using SEC Rule 506C which permits general solicitation, then you have the burden to prove that the investors were accredited investors. And there's industries out there that people go to that where, you know, there's E-Verify and others which would go through and verify. People can but provide their information to them and then it becomes confidential. But if you don't use those type of things, you might have to look at someone's, you know, tax returns to make sure that they're making the 2000 or you might, if there's a reason, you would have the burden to prove it. So you need to go through the process of proving it. So so it's easier to do it if you're not using general solicitation, but if you're doing general solicitation, you have the burden to prove that the person that you can only sell to accredited investors, that you can't sell to the 35 non-accredited investors. It can only go to accredited investors, and you would have the burden to prove that it is that they're accredited investors. So if you're raising money, the traditional way, confine your offers to people you already know. So these are the general solicitation rules, and reasonably think are accredited investors. You can get introduced to accredited investors through informal personal networks of angels is fine, or through StartupSac. They can provide you referrals. It's different than putting on a post, you know, on a website where you're saying, come to see me. You're going through people who have connections that have reasonable basis to do that. And The other way that you comply with not doing general solicitation is that you would limit your public statements to the company. So one, you like, for instance, if you are presenting at a conference, you either if you're making an offer of your securities at that conference, like presenting, like, here it is, and we're raising Series A money and we're expecting to do this. If you're interested, come talk to us. Then that could be an issue that you need to, that could be deemed to be an offer and a general solicitation because there's a room full of people. Some places like BankStart and other people, they go through the process of a credit, verifying that everybody that's at that at their events are accredited investors. So that's one way you can do it. Or the otherwise, if you don't know, is just to limit your public statements in your slides or otherwise. That's really kind of emphasizes what your company does and why they should buy your company and what the value of your company is, without really mentioning that your company money and that you're looking for investors at that point in time. It's a slight way of saying people understand it, and if they're really interested, they can come talk to you. Then you can start the conversation with them because you've made that personal connection with them without general solicitation. The next issue that some found, this has been an issue that's been coming up since AB 5 came into effect in 2020. Basically, this is California specific. And basically what this is saying, a lot of startup companies want to, they don't want to, they don't want to hire employees. They want to, a lot of times they'll do it through, informal, independent contractor arrangements. And what there are risks in doing that, especially with the new AB 5 test, which is basically saying, this basically set out, this is who is an employee for purposes of who can be an independent contractor or an employee. If they fall within this test, then generally speaking, the courts are going to view them as employees, and they will need to make sure the employees are being paid minimum wage, comply with California law, minimum wage, hour requirements, like, overtime, all those types of issues that could come up if someone is an employee. And so, so there are issues around that. So it's really critical that you understand the risk related to if you classify someone as an independent contractor and they should have been classified as an employee, then the company might have exposure to, for paying the employees employment taxes that should have been paid, providing overtime if they've been working overtime. There's some rules around exempt and non-exempt employees, but those are also, a classification issue that you might have to do, whether or not you have to pay overtime. But so here's the test that the California legislature has said. So if the worker is free from control, this is someone who is could be deemed to be an independent contractor. Someone is free from control or direction of the hiring entity in connection with performing the work, both under contract and in fact. So, they think about an independent contractor in this context as someone who is, truly just doing a project for you. They're doing that project on their own time. They're using their own resources, and then they're providing you the work product from that. But you don't control when they work, how they work, and how much time they work in a particular day or how they use it. So that particular one is free of control and direction from the higher entity, is one test. The second test is the most difficult one, where out of these three tests that you have to comply with. the worker performs work outside the usual course of the hiring entity's business. And what that means is that if your principal business is a software business, such, and you are trying to hire someone to do a software development for your work, the question is that person that work is inside the ordinary course of what the hiring business is, and therefore that person could be required to be classified as an employee and not as an independent contractor. So this what we're looking at here, and I'll go into a little bit more facts around this, but you're looking at what the company does, and if it's something that normally an employee would do within the company, then that should be someone that should be an employee and not an independent contractor, is what that really is, the concept is done. And the third test is the worker customarily engages in an independent established trade, occupation, or business of the same nature as the work being performed. So like if you hired someone, they're software, and they're doing some work for you, a consultant in some way, and they do similar type of consulting work with other people, and they're not working exclusively for you, then that would also be an indicia of that person being an independent contractor versus an employee. So I'm going to go to talk about these tests, just a few more slides, and if there's questions, we can talk about them going forward. So what is the manner of control of manner and means for the employees? And this is just some summaries. You decide the days, what days to work, hours of work, where the work is to be performed, how the work is to be performed, when to take breaks and for how long. So that's a control. They might provide some form of control over behavior or rules of conduct. They might say you have to dress a particular way, you have to use these tools and supplies, you can't use your own. So that's another way of control. If you wanted to have someone as an independent contractor, you would have to not be able to exercise these control over these people in the manner in which they would work. So the employer's normal course of business. So like these are just some examples. They're not really tied to what a startup company might do, but like these are what are truly deemed to be independent contractors. There's outside these are just samples. So, a retail store calls an outside plumber to come fix a leak. That fits all three of the requirements. This is not something that the retail store would normally do. It's hiring someone else to come in and do it. So that's why this one would be outside of the normal course of the employer's business. Similarly, electrician hired by the retail store to install new wiring, same thing. So these types of things, just to give you an idea, where the California is trying to get to truly what is a independent contractor versus someone who would be performing a function that an employee would normally would do in that context. So, and this is whether or not they're customarily engaged in a trade or business. The consultant or otherwise have established a corporation or sole proprietorship in which they're operating their business. They have their own business, they have their own space, they have any licensing requirements they do. So this just gives you some idea that this is what, that they're really independent from your business, and they do this on a regular basis, and you're tapping into their expertise in a particular way. Those people can be treated as independent contractors in this context. There are some exemptions for this, and here are some. They're as you might have known that last year in 2020 we went and Prop 22 was to try to provide some additional types of exemptions that were available, but here are the principal ones that are available right now. If you're, and as you could see through this, it's really kind of emphasizing the skills of the person, or that there really is a relationship outside the ordinary scope. Like if you're doing business to business, bona fide business to business contracting, where someone's acting as sole proprietor or business entity, and you contract to provide service to that. So that's, one exemption. If you have one project, like you're putting on a seminar like this one, and you're bringing in people to just help on this particular project, but not otherwise working on other events, that's clearly an exempt. That also is an exemption from this. Certain professionals services that are being provided are also not exempt from that. Like this list, typically people who have skills that are not normally within the scope of the business of that particular company, and some referral sources that like consulting and other things in this context is fairly limited. So those are, that's a high level view of some of the misclassification issues, but it is something that you need to probably talk to. If you have questions around that, you probably need to talk to a labor lawyer to help you address and analyze your situation to make sure you fit within those scopes. So the next thing I wanted to talk about is the proper use of form agreements. Obviously form agreements are beneficial for I use form agreements. Everybody use. It brings down cost for the employee, but you need to use them in a proper way. And here are some of the form of agreements that you would normally see that that when I'm working with the startup companies, I would normally give them a form of consulting agreement, forms of non-disclosure agreements, both mutual, where you're working, both parties are sharing intellectual property, or if you're just sharing intellectual property, so that's what I call one-way. Forms of restricted stock purchase agreements, which we've already talked about. Stock incentive plans, which we already talked about too in the terms of stock options, and employee proprietary invention assignment agreements. So use the form of the agreements that are there for the purpose by which they were intended to be used. And if you want to use these forms in a different way, you most likely want to have someone review that if it potentially create risk for you. But in the form agreements, you want them to be based on industry samples, and and use them for their intended purpose. And if you do it in this, I've had people who bring form agreements to me, and they might have pieced it together a variety of different sources to come up with an agreement, and they asked me to look at it. In essence, I would tell them it's more expensive for me to go through and correct your agreement than for me to provide you a form that's similar to that. So I always suggest that people, and the use of form agreements is also important when you're trying to raise capital from institutional investors and others. In many cases, they're going to ask, and we'll get into this discussion a little bit later in terms of some protection of IP issues. They're going to ask you to make sure that all the employees have an employee proprietary and assignment agreement, which is what I talked about in the previous slide. Basically, that says that if the employee develops anything during the course of their business, that they agree that the company owns it, and to the extent that there's any patent rights that arise out of that, they'll agree to assign those patent rights to the company. And this becomes important for investors, because the investors will want to make sure that these documents are in place, and they will want to. Typically they'll want to see you'll be making a rep or warranty that attached is the form of proprietary assignment agreement that we use. And if you use a variety of different sources and a variety of different terms, that you couldn't really make that representational warranty in there. So it's easier to be able to deal with investors going forward if they're all uniform in terms of how they use it, and and they're the proper type of forms for the particular type of purpose. Okay, next I wanted to talk briefly about protecting IP in this context, and some brief things that people should be aware of when doing this. So types of IPs that is out there: intellectual property, invention and know-how, the invention and know-how that you have, which is commercial or competitive. It provides a competitive advantage. Like, for instance, the knowledge that's there, if it was known by someone else, if everybody knew it, wouldn't have any economic value because everybody knows about it. But if you developed an idea or a concept which is unique and has value because no other persons are doing it, would be an intellectual property thing. So you'd want to look at making sure that you own that IP, and going forward. So another way that you also can commercialize IP by using licensing arrangements where you can license other people to use your IP, and you could have it generate revenue from that particular thing. So, and there also the way that you could, there's ways, as we'll talk about it later on, is that how you protect the IP would be a basis by which you can prevent other people from using your IP going forward. So those are the benefits of generally of an IP, but the principal question is that there's some economic advantage for people not knowing it, or you developed something like a new development and then you protected that through a patent or otherwise. Then there's different ways in which you could try to protect that IP, which we'll talk about. Examples of IP is what we just talked about. Is like, you could have your marketing and business plans. I worked with many companies, and and they could come from, like I work with an agricultural company, and someone who knows the watering cycles, someone who knows the planting cycles, when's the best plan, all those types of things has value to that company, and those could be value that if someone else knew about it, that they could use those plans, and it could they could take some of your business away from it because but anyway, there's some value in plans and that you might develop, that you might want to protect. Source code is another one. If you do a unique product or design, special recipes or formulas, like Coca-Cola's formula, which is not known, has some economic value, but if it had been known, then a lot of people would have the ability to make Coca-Cola without really, because it's not protected in any particular way. They only protect it by not telling people. It helps. I'm not really sure what that was mean. So, and then there's the basic types of ways in which you protect your IP. There's different. One is through you come up with a unique design or product, and you want to patent that particular design or product. Then you file a patent with the Patent and Trademark Office, which gives you the right to stop other people from using your technology in the way that's defined in the claims set out in your patent application. And so that becomes, if you are going to be going into something where a technology that could be competitive in other arrangements, a patent might be a way which you might be able to protect it. Some ideas may not be patentable, and so you would not want to talk to your patent attorney to see whether or not that's something that could work there. Another type of IP is your trademark, your name, your trade dress, how it looks. You know, like I've worked through a couple of clients which one of the things that you need to be, you know, like in a trademark, you define your, you know, you create a name of your business, and you want to use that business in your marketing materials, and that's intended to be valuable. Well, you would want to protect. First of all, you want to make sure that nobody else is using the same name in the same industry, and so you would do some form of search, a trademark search, to confirm that that particular trademark is not being used by someone else, and then you would file a trademark application with the Patent and Trademark Office, which they would review it, and to the extent that it is something that could be trademarked, something that's obvious, names cannot be trademarked, like if you use, you know, California Steel, those two names are too obvious, and putting them together is not something that could be created as a patent or trademark. So that's why we saw Google come up with the name Google, because nobody was using the name Google, and they were able to lock that name up across. And Google is, you know, something that has the name Google has tremendous value to that company, and so they've gone through the process of protecting that trademark. Similarly, copyrights are something that's written or drawn or something like that. So if you have code, you might want to copyright it, or there are different ways in which you could, both of these, you can do these in, you know, formally by doing it with the Patent and Trademark Office, but you also might have some copyright or trademark rights even if you don't file it, but you would need to be aware of those. And then the last one I want to talk about is trade secrets. And this is the concept. What we were talking about is that if you can't protect it from some other way, like a patent or a trademark, the way that you keep it have valuable is by not sharing it with anybody else. And and by not sharing it is called that creates the value by people not knowing what that is. And the only way that there are ways in which you need to go about to protect a trade secret. And let me see, I think I have it in this is, yeah. So a trade secret can only be protected by the courts if the business tries to take care of it. So what does this mean? You need to understand that the information is secret, and you need to only share it with people who need to know. You need to have an agreement in place with your employees to say that, you know, if they know about it, they can't share it with anybody, and you could prohibit them from, sharing it with other third parties. You enter into if you're going to try to share, if you're enter into an arrangement with, you know, a potential vendor or someone else that might want to buy your product, you would enter into non-disclosure agreements with those parties, so that they would be able to they would be bound by not disclose that. So the idea around trade secrets is that you limit who has the ability to see it to those who need to know, and then you build around contractual arrangements with those people who may need to know it or who may touch it, in order to protect it, so that you have the ability to prohibit them from doing it. If you don't take these steps, then a court may not enforce the trade secret, because they're only going to enforce it if you take the steps that are necessary to do that. So,
Chris,
yeah.
We had a question about trademarks. Alicia wants to know, if you pay someone to come up with your logo, do you have to have them sign a release so that you can get a trademark on it?
The answer to the question is yes. You would want to, this is the interesting thing with when you're using consultants in this context. I understand that you're hiring someone else to do the logo for you, and in that context, a consultant, when they do something for you, they own what they do, unless you have something in your contract that says that the ownership of that thing belongs to the company. So when you enter into the agreement with the third part with that consultant, you want to make sure that they are assigning whatever rights they have in that logo to you, so that they can so they won't have any residual rights in it.
And Chris, I understand with software development that it's very important in your contract with that software developer to say that you own the code, not the developer.
That's for the exact same reason. I mean, like, typically the rule in California is if someone is working at their offices, in your offices, on business time, on projects that belongs to the company, that relate to the company, the rule is that the company owns that. For a consultant, the opposite is true, as we just talked about. If they're doing something on your behalf, the presumption, it's not the presumption, they own it unless there's a contractual agreement to transfer it back to the company. The same, that's the reason why you would want to have those particular provisions in a software development agreement, to make sure that you own the IP. And sometimes there's some going back and forth because they might use something they've already developed before, which we call base IP, and they're not going to give you that. So you have, sometimes there's a negotiation in what they're giving to you and what the end result is and who owns what within that. But your agreements with your consultants should cover who owns whatever's being developed.
Okay, and we're on to the official question period. Is that right, Chris?
Yes.
So I'm going to invite people to raise their hand and unmute themselves when called upon to ask their question. But Scott Holman has a couple questions. So Scott, why don't you go ahead and unmute yourself and ask your question.
Okay. Hey, Chris. Hey, so we have this startup that we've been working on for a while, and we've had people approach us and say, hey, we want to work with you. And we know that since you're a startup, you don't have a whole lot of funding. So we'd like to exchange our services for company equity, which we have a lot more than that than we do capital. Now, do you have any thoughts or strategies for that?
Yes, there's a couple of points that came up in the slides that dealt with that issue. One was securities issues. You need to, if you are issuing shares to a consultant, then you need to make sure that you have an exemption that's available to that. And there's a variety of exemptions that are available, but the principal one, as we talked about in California, is that they have to be no more than 35 accredited investors and unlimited number of accredited investors. But in that context, the question is what is the offering on that? Who are you offering this to? A lot of different people on the same terms, then you have to count all these people that are doing this. If you're just offering to one person in exchange for services that are different from each other, then my view of that was that you're only having one offer to that one employee, that one particular person, and that is it. And so you could rely upon most exemptions that are available for that. The other one is whether or not the person should be treated as an employee or an independent contractor, which is the other aspect that we talked about. And in that context, if you can grant them options, you need to make sure it's at fair market value or that they pay fair market value for those shares, so we don't have any 409A issues related to that. And then you also, the question is if they are doing something for you in which they should be treated as an employee, then technically you're required to pay the minimum wage to be able to do that. And so I know this is a hard area for a lot of startups in how they try to structure their business. It's in the early stage, and if you're working with truly contractors who are doing this on a regular basis, like they want to provide you specific services and they're providing to other people as well, I think there's very little risk that you might have that they're going to be treated as, nobody's going to come back. The only way that anybody really going to come back and look at this, whether or not you misclassified someone, is if someone reports it to the EDD or something else. They're saying, I should have been an employee. They treated me as a independent contractor, and I should have been entitled to workers' comp. And there's class actions about these issues that happen all the time. So I would do it judiciously, and be cautious of how you do it. If you granting stock or options to them is fine, but make sure that you feel comfortable that this is truly an independent contractor in that context. Otherwise you could have some exposure there. But as I said, in early stage, it's rare that this is going to happen, especially if you have independent contractors who are used to working with a lot of startups and they're doing this on a regular basis. They're not the ones that are going to report this to the EDD. It's going to be if you hired someone who is a secretary and you say, well, I want you to be an independent contractor so I don't have to pay withholding taxes on your behalf, and I don't want to have to pay you overtime. That's where you have the real risk that comes into play. But the risk is still there.
Okay, so let's move on to Cedric's question. You can unmute. Yeah, there you go.
Hi, thank you for this seminar. This is great information. Second, I am technical problems, so if my video goes out, I'm still here. You just won't see me.
Okay.
But the question is, I've started a publishing company at the beginning of this year. I'm still sorting things out and structuring things, and I have, but I realize as I've been working on the products that I'm producing, that I prefer to do that and hire someone to really handle the marketing and the organizational kind of things, and even hiring other contractors. So I identified a person. I spoke with her last week and sent her a non-disclosure agreement, and so I want to go forth from there. But I was concerned about the compensation and all, so we haven't gotten into any deeper conversations. So just help me with my understanding. I was actually going to have her act as like the CEO. I'd be president, and so I don't know if those are proper ways to handle. It's an LLC, so I'm not sure how to go about the structuring of this and getting a solid agreement on. So that's really where I am right now.
Okay, so there's a couple questions that I heard from that is that, how do you hire someone through an LLC? I mean, this is one of the examples of the flex. One of the issues that you have with an LLC, you have to go back and look at your operating agreement or your LLC agreement to see what your authority is. I mean, if you are a manager of the LLC, then you might have the authority to be able to do that. So your LLC agreement will determine how it's operated and who is operating it, and so there's most likely, and many times LLC agreements will permit the hiring of officers similar to, and you could call them whatever you want. You can call them chief operating officer or anything, president within an LLC. But that's going to, how you do that is going to be governed by your LLC agreement. Just to reiterate the other comment about the misclassification, if someone is coming in and acting as a CEO, they can act as an independent contractor in that context, because they're doing something that's a critical function of your business, and it's something. It is your business because they're directing the operations of the company, and so it's unlikely that person could legitimately be treated as an independent contractor.
Okay.
All right, we've got time for one last question, and Rodrigo
Thank you.
had that question. Rodrigo, do you want to ask it?
Yeah, absolutely. Thank you, Laura. Appreciate it. Hey, Chris, thanks for so many good informations. I wrote my question here, but I'll tell it again. I started this startup. Actually, that was just an idea back then. About 3 years ago, I had like another person. Nowadays we are two, but back then we were three. And one of them was like a designer, like a visual designer, and he helped me implement the visual identity of my company. But short after he did that, he decided to leave the project. He had another personal commitments and decided not to be part of the project anymore. And then the project kind of stayed idle for some time until we really started working on it. And now it is a product. And I was wondering, and of course, we are still using that identity. So my question is, does this person has the right to claim any right over this this identity? We may have like emails back and forth, like some messages that prove that he worked on it along with me, but that's about it. And yeah.
Yeah. So from what I heard you say, there's a couple issues that, one was who owns whatever was being developed. If the person was, doing it at, just doing it on the side and then contributing something to you, there may be a question as to whether or not he owns that portion of what he developed on his own. So there is a question that's there, and the answer could very well be no, depending upon what you've done. But there may be a point where if he has contributed anything to the IP, to your intellectual property, and you want to avoid him, and he's making the claims on that, you want to avoid him having any ownership interest in the IP, you may need to develop around whatever he developed in order to go a different route that doesn't include what he owns. So that this is the important reason why we have the proprietary assignment agreements, whether or not it's in the employee form and a consulting form. The agreement should contemplate that the company owns whatever's developed out of that. So that's the one question, and it's not clear from your description whether or not he owns it or not. Really kind of depends on, are you using what he developed, in terms of in your current product, and if so, then you may want to look at, and he's still claiming it, you may want to look at a workaround so it doesn't include his IP.
I see. Yeah.
And the second one was, the issue that we raised about, offering people stock without really documenting that. If, as we talked about then, is that, you created a company 3 years ago, and you guys were both partners, and he leaves, and then you continue to develop things within that company, then his owner, unless you've dealt something with his ownership interest, he could retain an ownership interest in the company. And so this is all going to be facts and circumstances based upon what you guys discussed, but those are the two things that I picked out of your question that would need to be analyzed to discuss and answer it.
Sure. Yeah, I understand. Yeah, because we actually are still friends. We have contact, but
and if that's the case, I would recommend that you get it cleared away right away while you're friends, because many times, if you're no longer, you might drift apart, and you might develop something, and then the Facebook announcement, where the guys had an idea for original Facebook, and then Mark Zuckerberg took it, and there was a long litigation around that. Those are all these types of issues that you're talking about here.
Mm-hmm. Interesting. Well, thank you very much. Yeah, because again, back then that was just an idea when we were just discussing the possibility, and then right before we started really creating something, he left.
So I mean, really to really, I mean, he would only own a portion of. I mean, he'd own it in two ways. Individually, he would only own that portion of which he actually developed, right? So if you did all the development work afterwards, the question is the idea sufficient enough to be able to? I mean, you probably evolved over that idea over the course of a period of time, and so it may not be exactly what he thought about then, and so that's one question that you would think about when you're looking at that. So
sure, yeah, but it's certainly good to take care of that because he can eventually claim something.
Yes,
I see. All right, thank you.
Okay, so we're actually out of time. So I am, let's see. We're not going to go through the wrap-up slides, but I posted some links in the chat. There's a couple of events coming up you might be interested in. Tomorrow's 1 Million Cups, which happens every Wednesday morning. And then Wednesday at 4 is LinkedIn Essentials for Startup Founders. So that might be interesting to you. So I've posted the links in the chat if you want to grab those, as well as a link to the Startup Digest, which if you click on the Startup Digest, that's a weekly email that has all the best events for founders in the Sacramento region. You'll find all those events in the Startup Digest as well. So Chris, I wanted to thank you so much for this presentation. We've recorded it and we'll be sharing it on our blog along with Chris's slides in a few days or early next week, and we'll be sure to share that with everyone. So thank you so much for joining us today. Any parting words you'd like to say, Chris?
Best of luck. And if I can.
Best of luck, yeah. All right, and we'll send you Chris's contact information as well in that follow-up email. So everyone have a great afternoon, and we'll see you next time. Oh, there's a new message. Let's